skip over first 3 lines of the said paragraph. Then with regard to the government order dated 19 September 2022, whereby the government proposed to create supernumerary posts. Kindly underline this: government proposed. And the cabinet memo says, well, the School Service Commission proposed. These are very interesting feature. And whereby the government proposed to create supernumerary posts for assistant teachers. I say that the state government order came as a policy of the government for accommodating waitlisted candidates. That is also the government stand. The commission, merely being a recommending authority, has no role to play other than implementing the directions of the School Education Department, for which issued the notice dated 14th October 2022, which is merely a schedule for conducting and counseling of assistant teachers for work education, physical education. I deny that the notification referred to are in complete violation of Rule 12.4 of the Rules 2016. I say that Rule 12.4 deals with the primary, upper primary teachers.
Misquoting. This 12.4 is misquoting.
Misquotation. 12.4. 13.4.
13.9.
That I have placed also on the last occasion. Then he admits, I deny that there has been any violation of Rule 13.9 of the Rules 2016, as the panels and wait lists were published according to the said Rules 2016. But this is a very important submission on behalf of the School Service Commission. Therefore, this wait list, Milord, is related to 2016 selection, where ratio 1:4 was maintained. With regard to the petitioners being called for verification after creation of supernumerary post and creation, I say the question did not arise that the supernumerary posts were created for leftover wait list candidates who are actually successful candidates who could not be recommended for want of vacancies. And my rule, my lord, prescribe the detailed method of, my lord, declaration of vacancies at the time of advertisement and final vacancy 15 days prior to final publication.
Yes, that Rule 8 possibly.
Yes.
Rule 8. Kindly explain this situation, this 1:1. Supposing
I just give a Shiva. Now, my lord, I have vacancy, suppose X.
no, first of all, this supernumerary post would be, treated as vacancy.
Of course, so. But they admit that these wait list candidates, they could not be accommodated because there is no vacancies. Vacancies were notified as per the rules. And, my lord, as per the notified vacancy, my lord, they have invited for further interview, for further schooling or merit assessment, 1:1:4 ratio. If there are not 100 vacancies, they have to invite 140 people. By that process, the list is prepared, and according to the merit position, the top meritorious persons, my lord, who goes to vacancies filled up. The rest persons who are called for interview are placed in the waiting list. Why waiting list? Suppose a person, my lord, who was found to be in the merit panel within the 100 declines to join. Then, during the validity of the panel, person at the waiting list is offered.
No, whether this can be treated as vacancy.
Of course.
If it is treated as vacancy, then 13
9 has to be first.
has to be.
But that they say, the consistent pillar stand of the
And
authority.
in that event, the petitioners had a chance of
Everyone had the opportunity, my lord, to get a call.
how then by the cutoff mark will be lowered.
These are the now new vacancies, and the persons who are waiting may not be in the waiting list which has exhausted, they are also entitled to participate. When there are a vacancy, then you have to fill it up according to the procedure laid down under the law.
Mr. Bhattacharya, make it clear. Now, waitlisted candidates, why the candidates have been put in a waiting list? Because there were not sufficient vacancies there.
And therefore, these vacancies become beyond the declared vacancies.
Beyond the declared vacancies.
If it is beyond the declared vacancies, then you cannot appoint from the said recruitment process.
How your chance come then? If it is,
this vacancy now we have created X vacancies, it's open, who are entitled to apply as per the EGB, apply for these vacancies.
So this is a natural selection process.
Normal selection.
Normal selection process. But in a situation where if you treat this as vacancies, if you treat these as vacancies, how your chance?
I will not treat this as new vacancy. They say these vacancies are created after the selection was complete, after the appointment procedure was complete. Therefore, these are vacancy creation. They say we have created this for the waitlisted candidates. Why waitlisted? Because they could not get chance in the declared vacancy.
Now, I want to understand one thing. How if it is treated as vacancy,
at least
how the petitioner's chance comes?
Yes, but if it is a vacancy, then what would be the duty of the government?
To declare it and take it in the new selection process. In this selection process, if these vacancies, this supernumerary posts are treated to be a vacancy,
then what you have to do, you have to invite 1:1 ratio all the persons who are waiting. May not be the waiting list, but their standing might be below the so-called waiting list. But still, they would be below.
But they must have the beyond the cutoff mark.
Yes, might be so.
1:1.
Now, cutoff mark changes as soon as you create the vacancies. The cutoff mark was created for the purpose of filling up the declared vacancies. That cutoff mark cannot come for the purpose of consideration of new vacancies.
So you say that as soon as it is a vacancy, your whole thing
has to do afresh.
Including the fixing of the cutoff mark.
Absolutely. Everything would be changed. You admit that we created this vacancy to quell the administration. I mean the agitation. That is the admission in the cabinet memo. Since the people were agitating, to stop the agitation, we have decided to create posts for the agitating group. Can the state do this?
At that point, our waitlisted position same can I expect?
And since the and since the wait list conception is related inextricably with the selection procedure of 2016, this wait list has nexus with the select list. If the select list is complete, wait list vanishes. Apart from the question of expiry, the purpose of wait list is completely abolished as soon as the vacancies are filled up.
So creation of supernumerary indicates that vacancies have been filled up. There is no vacancy occurred due to non-joining or otherwise.
But if non-joining, then the person who is at the wait list, he will be offered. And
but
this
creation indicates that there is no such situation.
Vacancies are complete. We cannot appoint you. Don't agitate. We are creating vacancy for you. This is fundamentally against the basic principles of Article 1416 and in violation of the recruitment rules. I shall take your lordship to law later. But I am trying to emphasize on the fact that this is the persistent stand of the state and the School Service Commission as well, that the vacancies were created for a particular section. It may be for a privileged section. I use this term. Then may I complete this paragraph 9. they were dealing with 13.9, 12.4 was a mistake. They have also may not say. They have, however, just down the middle. However, I deny that there has been any violation of Rule 13.9 of the Rules 2016 as the panels and waitlists were published in accordance with the Rules 2016. This is, in my humble submission, full stop. You admit that you have published it. Therefore, exercise of power under Rule 2016 is exhausted. Then they say, and in the ratio of 1:1:4, with regard to the petitioners being called for verification after the creation of supernumerary post, I say that the question did not arise as the supernumerary posts were created for the leftover waitlisted candidates who are actually successful candidates who could not be accommodated for want of vacancy. How could they successful? We are also successful because we could not be accommodated in the vacancies. If there were vacancies were created, I'd create 20,000 vacancies. Everybody is successful. This statement of SSC is very interesting. On the other hand, petitioners, on the other hand, were unsuccessful candidates who were not even eligible for participating in the personality test. Because this personality test was vis-a-vis declared vacancy. If the vacancies initially was which you have declared and subsequent vacancies, automatically you have been called for personality test. Therefore, this statement of School Service Commission.
So it cannot be says that you don't have any interest.
Well, I am most vitally affected
of the supernumerary.
This is absolutely, if I may use some, the argument doesn't hold any water. This paragraph 9 of the School Service Commission affidavit is very important and interesting. Then kindly come to me, Lord. In paragraph 10, they are dealing with OMR sheets. I am not now troubling my Lord with that. No, actually.
You have to, you may have come back again.
I have to. I have to. Now, Lord, this is interesting. Kindly come to paragraph 14. I say, Lord, this is important. Because I had pleaded before your Lordship, which has been accepted by the division bench, upheld by the Supreme Court, that after the creation of this, School Service Commission filed application before the court saying that we have created this post to accommodate illegal appointees. As soon as we took up the point, they wanted to withdraw. The Honorable Court refused. They preferred appeal. Appeal Court, giving reason judgment, refused. There's no, it cannot be withdrawn. Now they are dealing that. With regard to supplementary affidavit, I say that the said supplementary affidavit has been filed annexing one can application so-and-so, which has been filed in connection with WPA, so-and-so, Shondip Prasad and others, which has no connection with the instant heat application, as the case of Shondip Prasad deals with the selection of Group D staff, which is a totally different selection process. Moreover, the purpose of creation of supernumerary as prayed for in the said can application is totally different from the purpose of creation of supernumerary post. That I have placed with that cabinet memo. This stand is betrayed that. As proposed by the government order the 19th May. Hence, the question citing the can application while challenging the government order does not arise. It may be noted that the Commission has given specific written instruction to the advocates to withdraw the said can. But the facts are out. But the cat is out of the bag. Now you cannot just say, I will put the cat again into the bag. Therefore, the both state and School Service Commission, Lord.
For a minute, a division bench judgment.
I paste that division bench judgment. But in this connection, I'll be placing, Lord. This is the division bench judgment. Lordship has seen so many petitions.
show me two paragraphs from this judgment which deals with the locus standi point.
Yes.
Paragraph 70 or somewhere I have seen.
No, the Honorable Bench has dealt with me lot subject-wise.
Paragraph 128 onwards. But my recording is up.
I will kindly come to alert, page 159. You can mention
Maintenance.
158, what's the maintainability?
Where I wanted to.
Paragraph
128.
We got paragraph 128 under the heading maintainability. Having understood the parameters of the matters, this is very important, which my lord also not thinking, what is the parameter within which locus has to determine. Having understood the parameters of the matters, which we have to decide the issue of maintainability of the writ petitions needs to be answered. Persons opposing the writ petitions have questioned their maintainability. In order dated so-and-so, the Honorable Supreme Court enjoined maintainable writ petition have been questioned on the ground of delay, laches, and writ petitioners being at the behest of unsuccessful candidates who had participated in the selection process and failed. Various authorities have been cited at the bar on such an issue, which we shall consider presently. My lord, I am not detaining my lord with the authorities submitted by the respective parties. Then kindly turn to my lord, page 164. Lord, I am not really detaining my lord with the issue of laches, acquiescence.
147 there was original.
Now kindly come to analysis of the cited authorities on maintainability. 146. Authorities cited at the bar have underscored the underlying principle governing delay, laches, acquiescence to defeat a writ petition to be estoppel and prejudice. In the facts and circumstances of a given case, if the writ petitioner is found to be guilty of such delay and laches so as to have allowed third-party rights to intervene and attain finality, can I underline this? Third parties' rights have been allowed third party rights to intervene and attain finality, then such a writ petition is not to be entertained. Similarly, when a writ petition is found to be acquiesced in a particular course of action, he is held to be estopped from questioning the same. However, these defenses of delay, laches, and acquiescence would not have application when the existence of fraud is established. No appointment can be made after the expiry of the panel. As the panel is not a perennial reservoir of appointments. Panel is valid for declared vacancy and for the specified period. Now, this will have apt application before your lordship also. Appointment towards future vacancies cannot be made from the panel. Appointment made in violation of Article 1416 of the Constitution of India are nullity. Courts have no jurisdiction to direct appointment to be made beyond the validity period of the panel. Now, I don't think your lordship need to go further on this particular issue. The nature of the writ petition. Paragraph 150, I just giving me the glimpses of facts in that issue. A candidate who had participated in the recruitment notification for third regional test 2016 for the post of clerk has filed so and so. He had averred in his petition that the board had issued a provisional appointment letter in his favor for such post on March 2020. He has stated that such letter was issued 3 days before commencement of the COVID pandemic. He had gone to school at which he was given appointment but was not allowed to join. He had prayed for a writ to allow him to join in the post of clerk. Writ petitioners in so and so alleged that they participated in the selection process for Group D. They have claimed that the authorities had acted dehors the 2009 rules by not publishing the fourth phase counseling list and not calling the petitioners thereto. They have claimed that the authorities did not prepare and publish the panel in accordance with rules and that the entire panel was full of discrepancies. They have alleged that the entire selection process lacked transparency. They have claimed that several candidates holding rank below them had been given appointment. Similar allegations here. They have given details of some of the persons who were ranked below them but given appointments. They have sought appointment to the Group D post and cancellation of the notification declaring the panel to be expired. But other factors are there, many things. And all, after having considered all this, the court says this is a issue is no issue at all. Then kindly come to me, Lord. Paragraph 160, delay on the part of the petition and maintainability, because they might indicate this.
So 163 thing. 160.
मतलब 163 on a on a purposive reading of the writ petitioners, one cannot arrive at the explicit finding that any of the writ petitions or the prayers made therein barred by law or do not disclose a cause of action. But I have been repeatedly arguing this before your lordship. The writ petitioners are entitled to approach the writ court with the prayers made on the basis of the pleadings as existing in the writ petitions. At the bare minimum, the writ petitioners allege misadventure by the authorities in the selection process. The writ petitioners are the participants of the selection process, albeit unsuccessfully by most, in respect of which they allege misadventure. They are entitled to a fair consideration in the selection process, a fundamental right under Article 14, denial of which they allege in the writ petitions.
166.
Then Lordship may skip over. Kindly come to paragraph 166. The nature of misadventure alleged is such that such allegation cannot be dismissed at the threshold or as not disclosing a cause of action to approach a writ court, or such allegation being barred by law must not be inquired into by a writ court. Quite to the contrary, if the statements made in the writ petitions are taken as true and correct, then they make out a case of transgression of fundamental right to be treated fairly in a selection process undertaken by the state authority. Whether the writ petitioners will ultimately receive any relief on the basis of the pleadings of the parties completed after affording the parties opportunity of filing affidavits and the prayers made in such writ petitions would be a different issue. On the face of the pleadings contained in the writ petition and taking such pleadings to be true and correct, on the principle akin to consideration of an application under Order 7, Rule 11 of the Code, it cannot be said that any of the writ petitioners are barred by law or does not disclose a cause of action, and that any of them must be dismissed as not maintainable at the threshold. This was my argument in brief. That Article 162 is the state's executive power. Extent of executive power of state, subject to the provisions of this Constitution. The executive power of a state shall extend to the matters with respect of which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution or by any law made by Parliament upon the Union or authorities thereof. Therefore, the executive power, which they say that we have executive power, cannot rise above the Constitution. And the public employment is governed by Article 14 and 16. This is now a settled position, which is a part of the fundamental right. Therefore, whatever executive power you have, you can exercise in the field where you have power to make laws. And in this respect, my lord, you have already made law for recruitment of teachers. Therefore, you cannot have any other power beyond the laws which you have made in exercise of the Article 162. And vis-a-vis this, just I take the liberty to point your lordship the stand of the state. Kindly takes up once again the affidavit of the state. Affidavit of state by the first affidavit, 28th of November, 2022. There is a fantastic way of claiming. Kindly come to subparagraph F. I just not place the important pleading or submission. The fourth line from the bottom of the same paragraph. Hence, it cannot be said that the teachers of a recognized aided institution are not in public employment. In fact, they are supporting in public employment. They have a government article 1416. Then, accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. And the larger framework of Constitution is only Article 162. And that Article 162 empowers you to work subject to the provisions of the Constitution. This is no power beyond the Constitution can be exercised. Therefore, Lord, they themselves have admitted that this has been done beyond the Constitution. Now, this is the constitutional position. Now, let us see how these issues.
They are suggesting that it is within the larger framework of Constitution. So they are required to trace their such power within the Constitution.
Yes.
Has it been explained anywhere in this?
Nowhere. No, there's no other power except Article 162.
You may not be knowing.
that I always accept, my lord. We live to learn. I cannot say that. But so far, so my knowledge, my lord, goes, Article 162 is only authority under the Constitution to exercise the executive power in the field which under that seventh schedule, second list, you can exercise. And in exercise of such power, you have already made the rules for recruitment. Therefore, you have no other power. Now, just for my interest, I will just refer to your lordship. Since this division bench has decided and the Supreme Court has upheld, few paragraphs relating to this supernumerary post. Now,
First, give me the paragraph number.
yes, I would just, I'm really tempted to read paragraph 350, 351, 352, 353, 4, 356, 357 and 350, up to 359 rather. I am tempted to make this, read these paragraphs which have some philosophical connection to the society.
360
and 360 also, yes. Now, the educational institutions have been admired, accorded special place in the society, and have been ring-fenced against the ills that may befall the society. Civilizations have made such attempts so that the future generation develops in an environment conducive for attaining the dreams of an individual student and caters to the holistic development of the student. Educational institutions are expected to produce better and evolved citizens who would be in a position to contribute to the society, nation, and to the mankind. Parents put their wards into educational institutions with the expectation that such educational institution imparts a level of education so as to assist the wards to develop into a better human being. Human beings are in control of any educational institution as in other institutions. If the teacher and the non-teaching staff of such educational institutions or even a portion thereof obtains appointments fraudulently, such teacher or non-teaching staff immediately forfeits his integrity, honesty, and his ability to impart wholesome education to a child in such an educational institutions. An educational institution must be protected against such elements attempting to percolate, let alone permeate into it. It is therefore imperative and in the beneficial interest of society that such elements are removed from an educational institution. Then important. SSC has filed CAN 2 such and such you have placed before a lordship, seeking permission for creation of supernumerary post for the illegal appointees. When objected to by the writ petitioner, SSC had sought to withdraw such applications. Learned single judge had declined the request for withdrawal by order dated so and so. A special writ petition had been preferred where an order dated November 25, 2022 had been passed. In the two applications noted above, the learned single judge had directed CBI to undertake investigation in respect of the creation of supernumerary post. Division bench had refused to stay such directions. Supreme Court had, by order dated November 25, stayed such direction. Stay granted by the Supreme Court in November 25, 2022 was against the interim order passed in the pending writ petitions. Lest it be contended that we have not directed measures to be taken in respect of creation of the supernumerary post on final hearing of the writ petitions and the appeals, we deem it appropriate to pass necessary directions with regard thereto also. Investigation by CBI with regard to the creation of supernumerary post is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by SSC for state-funded schools, knowing fully well that such appointments were obtained beyond the panel and after the expiry of the panel at the bare minimum. Now, this is important for our purpose now. The enormity of such wrongdoing is accentuated by the fact that the illegal appointments are sought to be confirmed in educational institutions. Persons involved in such decision-making process therefore have exposed children to persons who obtain their employment through fraudulent means. Unless there is a deep and pervasive connection between the persons perpetuating the fraud and the beneficiaries thereof, with persons involved in the decision-making process, such course of action in resolving to create supernumerary posts to protect illegal appointments is inconceivable. Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether such violations have resulted in criminal liability should be investigated into. Because criminal liability portion is stated by the Supreme Court, but Article 14, 16 has been upheld. Therefore, this supernumerary creation was also a part of the division bench judgment, which deals with the violation of Article 14, 16, which has been upheld by the Supreme Court. The next paragraph. Since at least a portion of the beneficiaries of the scam, that is to say that some of the persons who were appointed beyond the panel and after expiry of the panel and appointees submitting blank OMR sheets stands identified, it would be appropriate to direct such persons to return the benefits. I am not troubling my lot with that. Then, exception. During the pendency of these proceedings at para 360, learned single judge had taken note of the plight of one candidate, namely Shoma Das, and directed registration of a writ petition number with regard thereto. Shoma Das has subsequently filed in which an order dated April 18 was passed by a learned judge. There the learned judge had taken note of the medical condition of Shoma Das and requested the state government to consider providing her an employment purely on humanitarian grounds. In course of hearing of the matters before us, it has been submitted that the court should make an exception so far Shoma Das is concerned, since her appointment was purely on humanitarian grounds, which has been upheld by the Supreme Court also. We have considered the order dated so and so and find that request for consideration of appointment of Shoma Das was made purely on humanitarian grounds due to medical conditions of such person. Mrs. Shoma Das had been granted appointment by the state government purely on humanitarian grounds. Consequently, we propose not to disturb the appointment as state had granted her appointments on humanitarian grounds. She will stand outside the directions issued hereafter. On this discussion, ultimately, the Honorable Court was pleased to set aside the appointment. And the cabinet memo is basically based on Shoma Das's case.
What is the subject matter of challenge in the writ petition? Somewhere around it has been covered by
But in my writ petition here,
whatever the
our challenge is not
supernumerary.
No.
Rested.
entire selection.
No, so far the supernumerary. Your challenge to the extent of 19th May 2022 notice, creation of physical work. Whether that notice, 19th May notice 2022, has anyway the division bench has.
No. Division bench did not really go into the nitty-gritties of 19th May notification. Division bench while found that the supernumerary posts are created to accommodate the illegal appointees on the basis of the.
You have read somewhere, this is beyond the life of panel.
Yes. But this is here also. Kindly, I was placing the paragraph. Yes, paragraph 355. Paragraph 355, it says, my lord, that the appointments were obtained beyond the panel and after expiry of the panel at the bare minimum. Here also, my lord, the appointments ought to be given after expiry of the panel. And that expiry, my lord, is stated to be violation of Article 14 and 16.
Where?
My lord, next paragraph 357.
357.
Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether the violations resulted in criminal liability, but I am not troubling, that was said. Therefore, that apart, the other portion of finding that this violation of Article 14, 16 is upheld by the Supreme Court. Now, I will just place the order of the Supreme Court one second, Doctor. It is third. For candidates not specifically found to be tainted, the entire selection process had been rightly declared null and void due to the egregious violation and illegalities which violated Article 14 and 16 of the Constitution. As such, all the appointments are cancelled. But this is a conclusive finding of the Honorable Supreme Court that violation of Article 14, whether you are found to be tainted or not, is immaterial. Here also, my lord, this notification itself is not a violation of Article 14, 16. And when on the affidavit, they say we have executive power under the Constitution. Now, I may just point out once again, I have pointed out, Lordship, the affidavit of state. Affidavit of state, my lord, that paragraph is very interestingly drafted with all authority.
Election process held in 2016.
My lord.
A part of which has been found to be wholly polluted. How can the other part be so?
How can it revive?
Or like Ganges?
Yeah, that is not. How can it stay even for a single day? But if
it is your.
But if the supernumerary creation of post, they say subject to the pending of the writ petitions. They do not say that subject to the pending of the writ petition before Lordship, which was challenged after the supernumerary posts were created. But they say that all these petitions are pending before the High Court. I will show me this state's stand first. Justice Chidambaram order take it first. Chidambaram. Chandrachud. The state stand was that the supernumerary post, though created, no appointment was given because of pendency of writ petitions. Therefore, they also knew. Joshua দাও একটা কপি দিয়েছো
আরেকটা দিয়ে দেবো স্যার এটা দিন এটা মার্ক করা আছে
This is the first day order before the Supreme Court when state moved and got a stay. But on May 1922, the government of West Bengal issued an order creating 6,000 so-and-so supernumerary posts for teachers, non-teaching staff, for absorbing the waitlisted candidates and directed that the appointment letters to such waitlisted candidates shall be issued in terms of the recommendation SSC subject to the outcome of the pending litigation before the High Court.
This writ petition,
Yes,
all these three writ petitions,
all these petitions.
5 writ petitions, all these 250 to 256 are before me.
Hey, কি বলছেন যশ?
All these 250 to 256 are before me.
স্যার এইটাই নাম্বার হলো 25,056। এটা একটাই রিট
ও
আমার
তাই
হাইফেনটা হবে না।
Oh, I am also outdated. The writ petition number is 250256, not hyphen.
Oh, acha, acha, acha.
আমাদের এটা নম্বর কত?
250।
Yes, this is the
Oh, 250, not 2, 25056.
Yes.
1, 2 is excess.
that the hyphen is
And 2 is also excess.
2 is also
25056.
yes it was
now, my lord, therefore this is the stand. I'm just reading once again, Lord. During the course of hearing, this court has been informed that petitions under Article 226, this petition has been instituted before the High Court to challenge the order of the government creating the supernumerary post to accommodate the waitlist candidates. By an interim order, the government order creating the post have been stayed. Now, but this stay was not stayed by the Supreme Court. Since my lord, I had the privilege to.
Was it prayed for?
Because they prayed for that severe investigation against the state for creating supernumerary post. Please stay that.
CBI investigation.
CBI investigation.
But since the stay is already there,
No argument, because that was the sheet anchor of the defense. Since no appointment could have been given because of stay, therefore there is no criminality.
no, the background, I don't know whether at that point of time you were there or not.
No, I was there physically. That's my difficulty.
No, not that. This matter. In this matter, two things proceeded parallelly. The one is this challenge. Simultaneously, the direction of the coordinate bench to go into the CBI inquiry as to the decision
yes.
of that. That traveled through division bench to an SLP
Yes.
before the Supreme Court. Supreme Court stayed, division bench has recorded. That SLC is pending. At that point of time, this challenge was shown. And Mr. Gopal Mukherjee.
Yes, I was-
the
he said
learned
that
ad-
this issue might be.
No, I must say,
Yes,
he was a
yes.
man of stature. When I put him this question, that if you can assure this court that this challenge
Would not
or
be
the power of state to create such post is under challenge here, this issue will not incidentally would be raised in that SLP. He then took specific instruction of his counterpart in the Supreme Court, said, no, that assurance I
cannot be
cannot.
given.
Matter was time to time deferred.
Yes, yes.
Even the state took a stand that no, we are not going to give any appointment now.
That's clear.
So why the matter was deferred?
Because of that.
Pending issues are there. In the meantime, division bench.
And then my lord directed the state to file an affidavit specifically stating that
Exactly.
whether this will clash with the Supreme Court determination.
They refused to.
SLP
Therefore, my lord, this stay by this court, my lord, in respect of appointment vis-a-vis supernumerary post was their, my lord, defense.
To get the stay of the
Criminal
CBI
investigation.
inquiry.
কুমার দাসের acceptance Supreme Court দিলেন, ওটা একটু দেখিয়ে দেবেন কেন? Paragraph 47, it only restricted to Kumar Das, entire thing is back.
সেটা তো বলেছি অলরেডি
Supreme Court
I have already probably I'm repeating being
Prompted by
poked by, I just say prompted. Now the Supreme Court dealt with the Shomadas issue, paragraph 48.
on 3rd April.
Yes, that's similar to the base order.
Yes, lastly.
Lastly, we address the case of disabled candidates Our attention has been drawn to one such case where the impugned judgment held that the appointee Shomada shall be allowed to continue on humanitarian grounds. That's important. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. Therefore, Lord, many, kindly don't take it otherwise, many dramas were created in the court of the Supreme Court. Certainly, my lord, some visually disabled persons, they were brought in court to argue, in spite of their senior counsel having argued. The Honorable Chief Justice heard them and said, I'm not going to give you benefit. And that's the finding at page 48. Shoma Das is exceptional. She was suffering from cancer. The court not felt if some concession can be given. Therefore, that cannot be, my lord, a ground. That's why I say that will really contradict the main finding of rule of law. That is paragraph 48. And rule of law is Article 1416. And the state in its affidavit firmly says that we have our administrative power. I had pointed out to your lordship, note, I again point out, my lord, that this is the stand of the state at page 8 of their affidavit, subparagraph F. Subparagraph F. E. You could have placed, I am not troubling, my lord. They say the validity period has expired is an irrelevant consideration for creation of supernumerary post. This is where, yes, that is subparagraph E, last line. Subparagraph E starts at page 7, continues to page 8. State, having made statutory rule, now says that is immaterial consideration. Then it is stated that subparagraph F is very interesting. This is source, they say. Last 3 lines. Accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. This could have been a new addition to the constitutional jurisprudence. Statute maker says that the statutory empowerment is immaterial. I have higher constitutional authority. What is this? Article 162. What the Article 162 says? Subject to provisions of the Constitution. You can take a decision in the field which empowers you to make law. And having made law, you take a stand saying that this is immaterial.
Is it lack of understanding or to save a situation?
To create more chaos in the society, not to save a situation. Lordship can take judicial notice of this fact that this has created huge chaos in the society. I do not travel beyond this, but this has, everybody must have taken note of this fact.
Who is at the receiving end?
Bikashwaran Bhattacharya. Why did he raise this issue before the court?
Or
why did he argue that the entire panel should be set aside? He should have argued that the corruption should be prevailed.
So ultimately the candidates,
ultimately they are misguided people. Anyway, I restrained myself, my lord, from making this statement. Therefore, the stand that we have a constitutional power, my lord, belies the specific words mentioned in the Article 162. There is no other power by which state can exercise executive power to do something. Now, the next question will be whether the judicial review is permissible. That point has been mentioned and taken by the court to judicially scrutinize the order passed by a cabinet. It means that if the cabinet tomorrow says that I let annul all the terrorists who are imprisoned free, that decision cannot be reviewed. That's the stand, but that's not the law. I will take a shift with law. তাহলে পরে হবে
Did you cite that 2006 to SCC, the Vagela's judgment?
Yes, not in that matter.
In some of the Article 16, which finds place in the Part 3 of the Constitution relating to a fundamental right,
Right.
provides that there shall be equality of opportunity of all citizens in the matter relating to employment or appointment in any office under the state. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in the public offices. The word employment or appointment cover not merely the initial appointment but also other attributes of service like such and such.
But it was cited by me in Darjeeling matter.
Yes, you had cited,
Blood.
but I have used it in another matter.
There is all
In Arjikor matter, I have used it.
Similar judgments are only common in both matters.
So, Article 14 and 16 ultimately has to be adhered to.
But it's a fundamental right. No one has any authority to act in breach of fundamental.
162 does not give that much of power.
It starts saying subject to provisions. The constitution makers knew that may at some point of time some people may come to power and they say we are the monarch, therefore we can do whatever we like. And Ambedkar said, don't forget, we have a written constitution, we have a limited government. These issues were discussed during the constitutional debate. We have a written constitution and this is a limited government. No one has authority to act beyond constitution. Now, the heated debate is going on. Lordship is aware. The Supreme Court has said even the governor and the president doesn't have the ultimate discretion to sit over the decision. They have to give a decision within a certain time. Normally in Madras governor matter, the president has been pleased to make a reference. Supreme Court will reject it, I am sure.
Here, even the legislature has framed a law, has legislated a law.
The field is occupied.
Occupied field. Now, what is this saying? That it should fall under larger framework of constitution. Not, so he is given by the
statute.
Legislative field goes banks on the constitutional provision. That is under Article 62. 62 limits the power subject to the other provisions. So now you will be citing judgments now?
Yes, I will cite.
Can we continue when?
Whatever time your lordship allows me.
Because I don't know who is for the state now.
Advocate General was there.
Very well, because this week it will not be possible for me to accommodate. Let me come back with a fresh mind.
Where are you going?
Andaman circuit, then I will take.